So I can make testamentary distributions right from my prenup. I'm going to say these personal items, I want them to go to my family. I want this to go to this person. I want this to go to that person. There's no reason you can't do that in a prenup so long as it is executed as if it's a will. Otherwise, a violation of the Sacred Wills Act. The Wills Act goes, believe it or not, back to about 1500, literally 1500 England, 16th century, we'll say. And it's the Wills Act, requires these solemn things in order for something to be valid as a will transfer.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome. This is another episode of Life's Third Act. Today we're doing episode number 2 in the life of Kyle Jacobs. So in the first episode, we talked about what had, his early life really up to toward his death. So we kind of covered his life. And now we want to talk about the end of his life as well as the things that happened thereafter that are pretty interesting. So we hope you'll enjoy it. Let's get started. As it stands, we know that Kyle dies. They have no kids. We know that there's a estate filed to be opened. Now, the only potential heirs in the laws of virtually any state under these conditions, where you have a wife, no children, but surviving parents. Almost all states would say those are the only potential heirs. So that means that either the wife gets everything, as in many states, or some states will give the parents something in that case where there's no kids and surviving parents. They'll give the parents something. Turns out that in Tennessee, which is where they lived at the time of the death near Nashville, it turns out that the law apparently gives everything to the surviving spouse. I'm wondering that in this prenuptial agreement, even though we know Kyle was close to his parents were involved in his life, and there was a close relationship. So let me make that clear. Otherwise, people be scratching their heads and saying, why are parents involved in this at all? But in this case, you have a wife and you have parents, and they all were close to Kyle. So my thought when I heard about this, as well as a prenup, was that he had a prenup that was entirely divorce-focused. That's one possibility. Or he had a prenup that said that these things remain mine in the event of my death or a divorce. Well, the problem with that provision is if you don't have a will, then the effect is that you die by intestate succession. So let's assume that the prenup had a provision that said, I want all my assets, whether I die or get divorced, this category of assets, which in prenups you define those. It's usually not everything. I mean, a lot of things you get together, you want to be marital things. But then you can cordon off certain things, and that's the beauty of a prenup, is deciding what things you want to cordon off. You may cordon off any of his intellectual property, for example. And if she agreed with that, that's going to be enforceable. Even against an election right, a spousal election right that exists in most states, where if you're a spouse, you can elect to take against a will. But if there's a prenup that anticipates that and the wife has waived it, I say wife or husband, but anyway, the surviving spouse waives it, then that can't be asserted as it otherwise would. But in this case, we had the prenup in which we'll assume that there was this waiver and there was this portion that's set aside to Kyle. Kyle dies without a will. So we have what now is the laws of, big phrase, intestate succession. All that means is what kicks in is what the legislature says is going to happen to people's stuff when they die without a will. That the legislature makes certain assumptions about what do people typically do, and that becomes the law. So in this circumstance, intestate succession, as I mentioned, everything goes to the wife. So we have a prenup that sets aside some assets, we'll assume, for him in the case of death or divorce. He dies. So now these things are his, not hers, right? He dies. They go into his estate. Guess what happens to them? Intestate succession, it all goes to her. So it just seems like a bizarre set of circumstances if that's what happened. Now, why do I even think that anything else might have happened? Because it does seem like one way or another, it looks like assets are going to end up in her hands,
Kellie.
right? Mm-hmm. There's no will and laws of intestate succession. But the parents have stepped forward here, and they have made themselves quite prominent in this
Yes,
proceeding, and I don't diminish that at all. I think it's marvelous, and they are concerned about some things things I guess have great sentimental value to them. I don't think this is about financial value, to be honest with you, because I've looked at the assets and whatnot. In terms of estimating what Kyle is worth, it's really hard to say. I've seen from $4 million to $8 million.
Mm-hmm.
I saw $8 million.
Well, I know Kellie's worth that as well. Kellie's on her own worth $4 million.
Okay, so it's really hard. It's going to be a flow of money to somebody for 70 or so years for songwriting rights, and it would be significant given the number of hits he's had. Mm-hmm. And if these people that are moderately successful now, like the people like in the Doors, primarily produce their own music. Morrison did and others, but let's say that we'll use Doors as an example. Their songs didn't become big till they were gone, and really big. They had some hits. Yes, they had hits, but they really hit. Their streams of income went way up, and that's not unusual. So some of these songs that he wrote may see dramatic increases in sales depending on the artist. They won't be driven by him. They'll be driven by the particular artist.
Yeah, especially when you're talking, again, Garth Brooks.
Yeah, yeah. So anyway, it's a long stream of income. How do you value that? But $4 million, I thought, how can $4 million be correct? That must be without assigning much future value. Maybe it's without assigning any future value. But the IRS is not going to be interested here. So there's lots of opportunities to value this down. The IRS is not going to take an interest till you get north of your exemptions, and your exemptions for an individual now I think are like $15 million apiece. So he's not worried about federal income tax at this point. But I do think that this estate may be worth substantially more than will be valued on the inventory.
Well, especially, like you're saying, maybe he is worth a lot more when we get into this list of assets too, because some of the things that are on there, you don't know what's in there.
Yeah, but those are mostly personalty. We'll talk about it. But those are mostly, but they could. I mean, it could be something very valuable.
Because we're talking about computer, they want.
Yeah.
So that's where I'm like, what's on the computer, the hard drives and things, you don't know what's on there.
Well, yeah. So I think that in this case, the parents are interested. There's a significant amount of money, but I think from the documents that I've read that they're interested more in really the list you refer to, the personalty. But I get the sense that it's about things that have great sentimental value to the family, like a gun collection, et cetera. But we are a little bit in the dark about if the parents have any claim to inherit anything from the estate. That's what troubles me is unless he specified in the prenup, which he may have put in his prenup that in the case of death, I want specific things to go to specific people. Mm-hmm. Now, that's a way to get around the problem I just described, because the problem I just described happens when you say, I want, as is the forethought in people's mind when they're preparing prenups, is they say, I want to be sure that this is set aside to me. It's not about estate planning usually. So if he went that additional step and said, well, I'm going to make this equivalent of a will, so I can make testamentary distributions right from my prenup. I'm going to say, these personal items, I want them to go to my family. I want this to go to this person. I want this to go to that person. There's no reason you can't do that in a prenup so long as it is executed as if it's a will. Otherwise, a violation of the Sacred Wills Act. The Wills Act goes, believe it or not, back to about 1500, literally 1500 England, 16th century, we'll say. And it's the Wills Act, requires these solemn things in order for something to be valid as a will transfer. So there are some accommodations to that, and in many ways there are devices where we get around that in today's world. But if anything purports to give something as I just described, it's going to be a violation of the Wills Act if it's not properly executed. Executed just means all this solemnity that takes place around the signing of a will. Those of you who have wills should know. Those who don't, you should have a will. But it means that you gather around, you have somebody notarize each signature. Most states you have at least 2 witnesses present and observe the signatures. Sometimes you have to have a solemn statement by the testator that this hereby represents my intentions as a will, language to that effect. So as long as you include the proper execution in a prenup, then yes, things could have been given that way in the prenup. So if there was no need for a will, maybe that's the reason he doesn't have a will. But I'll tell you, that's unusual. Normally what's done, and I think the much better way to do it, is to simply put the provisions that in the event of death or divorce. So when you think about death, you only think about the things that would go to me individually. Or they're my separate property, and leave it at that. And then later do your will or your trust and other things as separate documents to deal with the things that you own when you die. So you set aside what's yours at the moment you die. It's not going to you after you die. You have it before you die while you're married, and you have it at the moment that you die. And that means you can then go and do your estate planning, and you're good to go. In this case, step 2 didn't happen. So I wondered, did he try to compress steps 1 and 2 into the execution or the signing of this prenuptial agreement? And that may have happened because, and the only reason I think I looked at that as the only explanation for the fact that the parents seem to have some claim here to these things. And there's a lot I don't know here, so there is speculation. I had one of our attorneys from our Nashville office or Knoxville office, probably the Knoxville office. We had somebody pull these from the courthouse. So I wanted to get a sense of what the documents were so far. There is a contest between the parents and between Kellie and the parents. And Kellie's living in the home.
She's actually sold the home now.
Oh, when did she sell the home?
She sold the home earlier this year.
Oh, and she has these items in her home.
Yeah, she sold the home last year. She sold it May 2024 for $2.3 million. So she got out of there.
So the home that she's in now is the home where these personal items are kept.
Yeah.
Because right now there's a dispute about gaining access to go in and inspect those things. Well, previously, when the home, I guess, was in their joint names, or it could have been his name alone, but I bet it was
it was both their names, yeah.
Joint names. So there was more opportunity for the person who's acting as the administrator of the estate to try to go in and inventory assets. That's one of the responsibilities. But they were having trouble doing that. So that still apparently has not been accomplished. Anyway, so it's interesting. So this house was sold. She's living in another place now, correct?
Mm-hmm. Yeah, she's living on her own now. But the whole possession of his things, there was a back and forth where Kellie didn't want to be, what do they call it? The executor?
Yeah,
right?
well, wait, hang on.
Okay, because we missed that part.
No, we're coming to that.
Okay.
So then when he dies, and normally the person that would be appointed under these circumstances, not surprisingly, to lawyer or non-lawyer, it would be the surviving spouse. I mean, there are no kids. Parents, they're not go-to for appointments in this role. And the most likely person to get everything, Tennessee law says, is the surviving spouse. So she could have walked into court and they'd have handed it to her, said, look, you be the administrator. Mm-hmm. And you may be saying, well, why is that important? The administrator has a lot of power. They have a lot of authority. Their job is to be the arms and legs of the court. They're supposed to go out, gather all the assets, identify them, secure them in some way to assure they're safe. It doesn't mean literally pulling them out of the possession of everyone. But if you leave assets in possession of people, you have to be sure that they're properly stored and kept. I mean, you can imagine somebody dies and they have assets spread all over a county if they have a lot of personal property, not to mention financial assets and institutions. So you can see how urgent it is to have somebody appointed to be in charge, sort of CEO of this person's estate, to put it together, figure out, Judge, here's a list of all the assets this person owned at death. And here's this thing that is a will, and we believe this will is valid. And here are the people that, according to this will, are to receive this property. And here, importantly, here, Judge, is the list of creditors that we've been able to identify, and they're, of course, to be paid first. Unfortunately, those of you may not be happy to hear that your creditors will get anything before you do an inheritance, which we all know is right and fair. Anyway, so being a personal representative or being an administrator is an important role. In this case, for reasons I don't understand, Kellie didn't want to do it. And I don't think she didn't show up. Somebody told me she didn't show up the day of this hearing, but I think that she had indicated that she didn't want to do it. It was stressful. It was going to consume some time, and she would just let his parents do it. So his parents came forward, apparently with Kellie's blessing by all appearances, and they were appointed administrators.
Yeah, it sounded like the beginning everything
apparently was good at that point. And what's more, she agreed to have them do things without having to report to the court. They can assemble the list of assets without reporting to the court. They can identify creditors without providing that list to the court and the court approving it. In other words, apparently there was a good relationship at this stage.
Sounds like there was trusting going on.
Yeah, there was trust. Something went south. So this authority, I'm looking at this appointment. I have here the petition for letters of administration, and this is the means by which you're appointed. So this was, they previously filed their petition for letters of administration. These are the parents on May 2nd, 2023. Then not long thereafter, they filed for an amended appointment, and the amended appointment just gave them more latitude, as I just described, that they don't have the requirement of an inventory and accounting to the court, so that's waived. So, you have what's called a supervised administration, and then you can have an unsupervised. Unsupervised is where you really trust the person and or there's not much at stake, there's not much in the way of assets, so why incur the costs that have to come out of the estate anyway? So things are at this stage hunky-dory. And then we find ourselves shortly thereafter with this blizzard of pleadings in which there's a dispute mainly about personal property. So it brings to mind the suspicion, as you voiced, Sherry, that maybe there's more value here than it appears, but I don't think so. So let me give you we have here this subpoena, which was issued 5/13/2024, so May of last year. And it has a list of assets. And so this is called a subpoena deus tecum. So what a subpoena deus tecum says is that this is an order for you to bodily appear at such and such address at such and such time and to bring with you the items attached. So it's an order normally subject to an action for contempt if someone fails to abide by it. That becomes an issue in a few minutes. But let's look at this list of assets. We have firearms.
A lot of firearms.
So, yeah, there's a long list of firearms. I don't see these as antique items, but who knows, or valuable items. Large gun safe and custom knives made by Eli Leathers for Kyle. Kyle's swords, including his samurai Japanese sword. Anything else contained therein of Kyle's. Rolex watch, Garmin watch, jewelry, all rings, including Pirate Ring 30A.
I really want to see the pirate ring.
Well,
that just fascinates me that was listed. So there must be a lot of, like you're saying, sentimental value to that ring.
Now, here's something with substantial value. A 1957 J45 Gibson guitar. So we're probably talking well into 5 digits. McPherson KOA guitar. Baseball card albums, cards, pictures, school awards. See, I think the parents are really after things that aren't so much about finish. I don't know why she wouldn't just give these to them.
But what about all intellectual property that's listed there?
Oh, wait, hang on. Let me get down to this.
That's number 9.
Military challenge coins that belong to Kyle in display racks. Military challenge coins?
They did a lot of going overseas and entertaining troops.
Oh,
Kellie was
okay.
big on that. And the two of them that did that together. And oftentimes when you meet someone in the military, they may give you that challenge coin.
Okay, so yeah, under what they're calling, all intellectual property. A is iPhone, including chargers and cords. 2 is work laptop, including attachments, hard drive, and all components. C is orange lacy external hard drive of the contents of Kyle's computer. prepared by Jared Ackerman for Kellie. Let's see. Then there's all other external hard drives. So it says intellectual property. Sounds to me like property, but it does include information. Yes, it does. So because it's not just the equipment, it's the data on the hard drives. So Steinway Grand Model M piano. It has significant value. Viola. But again, these may be things that the parents care about because it's their son.
And you never know. They may have bought him that viola. And I
Yeah.
bet they probably had something to do with that pirate ring. You know?
Yeah. So all items from the studio closet, blah, 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 file cabinets, oval metal, metronome, black case CDs, boxes. So is there another? Jeez, it goes on here. Sheet music, weapons standing in the back of the closet, any and all other assets of the estate that may be in possession of the respondent or respondent's brother or any other person, including such items as may be stored in a location outside. So now they can say, in technical terms, that their job is to identify and to secure or to assure the safety of, which might be that she keeps it in her possession, of items. That's their job. But what makes it kind of pointless is that they're securing it for the sake of the beneficiary, assuming that there's no creditor out there that's going to claim, all the estate, which I think I haven't heard of any such creditor. So assuming that's not the case, then I'm wondering why would they go to all this trouble to secure it for her when she's the only beneficiary? So they're doing it to secure the asset for the person that has it. And I don't believe that's their argument. I think they have some claim, and I have to confess to you, I didn't see in these documents what it was. Now, granted, I didn't read every page of these 70 plus, I don't know how many documents there are. In terms of documents, there's at least 20. And then pages, I don't know. But so just to give you a taste of some of this back and forth, so they send this subpoena to her, and they give her a certain number of days to be present at this address with these things or to have access to these things, to provide access to these things. So she hires a lawyer. This lawyer files co-administrator's response in opposition to motion to quash and for a protective order. So, these arguments here, and you can tell there's such sarcasm. These lawyers must hate each other. They both seem to think the other one doesn't know what he's talking about. And sometimes these save their sarcasm for the clients. In other case, they suggest that the person drafting the document doesn't understand the law. That's obviously not an argument against the client. So it says, here we go. I'll just give you a tone. Ms. Pickler has moved to quash the subpoena duce tecum, what I just described to you, served on her on April 29th of 2024. All of Ms. Pickler's arguments turn a convenient blind eye to the months of discussion with her counsel concerning the items of descendants. So let me clarify something. When I say this is a motion to quash, this is in opposition to the motion to quash. So let me take a step back here, and then this will make more sense. So here is a motion, what's called a motion to quash, and the motion to quash is something that Kellie's attorneys filed because they wanted to have the court to tell them they don't have to submit and appear for this subpoena duce tecum. They want an order by the courts called a motion to quash and a protective order. The protective order is saying that for them to have these goods and for them to be able to not appear at this place they're protected for the time being until there's such a hearing, et cetera. So they filed a motion in support of it, and the Jacobs allege that Ms. Pickler's motion is not timely because her counsel did not object to the subpoena within 21 days. Respectfully, the Jacobs failed to comply with Rule 45, blah, blah, blah. Let's see, Ms. Pickler's counsel communicated in writing to counsel for the Jacobs and made clear that she would not be appearing at Neal and Harville, the law offices, to hand over the items on May 9th. At that point, Ms. Pickler fulfilled her duties to object to the subpoena. Contrary to the Jacobs' suggestion in their response, there was no deadline for Ms. Pickler to file a motion to quash. They argued that she had waited too long, that she had to file that immediately. Moreover, Ms. Pickler went to the root of the dispute and filed a declaratory judgment action, a new source of litigation, declaratory judgment action regarding possession and title of those items. So what she's doing is she's bringing an action that is peripheral to this. And all a declaratory judgment action does is you go to the court when there's a dispute over something and say, Judge, I just want you to resolve one dispute. Do I own this stuff right now? And if I do, that's all I want you to do is bring the gavel down and say, it's our declaration, declaratory judgment, that this property is owned by, in this case, the surviving spouse. So she brings an action for declaration because she thinks she can preempt all this because she thinks she owns all this. And as I just explained to you, I don't know what I'm sure the parents have some argument, but I'm not sure what it is. So, but she, according to what she's saying, she's kind of thinking, no, they don't. This is all mine. It's obvious it's mine. And why are we doing all this? So she files this lengthy, the subpoena exceeds the scope of permissible discovery, that Jacobs had admitted both in filing representation to the court that they sought to dispossess her of these items. And then the tone gets increasingly harsh. So then you go from this motion to quash to here's a response in opposition to the motion to quash and for protective order. Ms. Pickler has moved to quash the subpoena duce tecum. All of Ms. Pickler's arguments turn on a convenient blind eye to the months of discussions with her counsel concerning the items of the decedent estate. So there's lots of more and more sarcasm in these as you go through it. Decedent Kyle Jacobs died February 17, 2023. This action was instituted to administer his estate. Several items of decedent's personal property were located at the Jacobs residence at the time of death. And Ms. Pickler provided administrators with her inventory of the decedent's personal items. Over the course of the ensuing months, administrators attempted informally to recover those items through discussion with Ms. Pickler and her counsel. Says she did release some of the assets, but she hasn't released others. Then it becomes very legal here about statutes that would waive their obligation. So there's also an argument here where Kellie is alleging that they came into the house and went through her stuff. And then you see when the response is that she gave them permission to go in the house and that she was there for part of it, apparently. So there's lots of back and forth, but it seems to center on this personal property, what the law calls personalty, meaning anything that's not real estate, essentially. So I won't go any further into now. There's been a motion for contempt filed, and in the Jacobs it's alleged are violating the court's order, and they're asking for sanctions against them, that they pay attorney fees. Then there's a response to the motion for civil contempt.
It's adding up here.
I mean, I have this pile.
A lot of stuff.
So I confess to you, my viewers and ardent listeners, that I did not read all this, but I read enough of it to tell you that you don't want to leave hazy things like this in your estate. Yeah. This is, quite frankly, though, this is an unlikely dispute. I have to say, out of all the things that can go wrong in not having a will, I mean, he had no kids. So no problems there, no kids outside the marriage, no relationships with women that had claims, no mysterious creditors out there that he had signed away the house to or some other thing. All those things that could be bad, that often go wrong in wills or in situations where you don't do any estate planning, where it's a will or a trust. That didn't happen here. So you think, okay, in this case, the law is going to give it to his wife. But it hasn't happened that way, and I feel sympathetic with these parents. I mean,
they've lost their son.
I know, and I would think that this could be resolved. I would think that you would give the parents generously of these things, but they mean something to her too.
Yeah, well, I should say all three of them, his dad, his mom, and then Kellie. Maybe they just. Again, I know I wear my rose-colored glasses, but maybe just time, because when someone takes their life like that, and it was unexpected, they all are just heartbroken, and the emotions are so all over the place, you know?
Yeah. Yeah, and I'm sure that's part. I'm sure if some water had gotten under the bridge, but the parents' concern might have been that these items would disappear. So maybe I'm sure over time, as things come out in this litigation, if not quickly settled, and I hope it is quickly settled, but then we will find out what this claim is for the personal property by the parents. But it's interesting to me what that might be. But I am sympathetic to the parents. There was an allegation, which this might have set matters on the wrong pace. There was an allegation according to is it IMBD?
IMDb, Internet Movie
IMDb,
Database.
which Justin trusts, and I trust. It's a Internet Movie Database. Very reputable. As a matter of fact, we use them. We go to that source for information about recordings, movies, lots of things, and it's this incredible database. But on the news, I don't know how accurate they are, but there was a report that the parents had insisted that the police open an investigation, that they thought that there were suspicious circumstances surrounding the death of their son.
Yeah.
I hadn't heard that before, but because it's coming from this source, I thought maybe there's some truth in it. If there's anything that'll poison the well, it's for the parents to imply, and I don't know that they implied it. It sounds like they were implying the wife may have had something to do with it. So that definitely could have put things on a bad path.
Yeah.
Do we know when that allegation was made?
I believe it was 2024, maybe May of 2024. Let me see if I have that.
I want to make a correction, too, because I realized as I was reading this court document that I'd said previously the date of death was in 22, is in 23.
That article that you're referring to is May 2024.
May 2024. So this was early on. This could explain a lot.
Yeah.
This could explain a lot. So anyway, all right. So what more can I add? Sometimes, I have a list of lessons. I've pretty much articulated those things as we've gone through this. And here, if a will had simply been done, I think that all these problems would have been handled because I do think that the son would have given things to his parents. I don't doubt for a second that there are things that Kyle would have wanted his parents to have.
Definitely.
And hopefully his wife keeps that in mind. Because he was derelict, and I don't know another word to use, he was derelict in terms of not having any estate planning, even when you're young. But we don't know what was in the prenup. So, but I do think that the lessons here are not subtle. And I think that all of you are making mental notes as we talked this through, and I hope it's been helpful to you, and I hope it's been interesting too. So keep Cordell and Cordell in mind when you do your estate planning. We want to find evidence that this show has actually produced revenue.
Yes, you'll save 15%.
Revenue to Cordell and Cordell. So we're going to actually start monitoring that for ourselves. In the past, we never did. We just assumed this is something I really enjoy doing, which I do. And we thought, it has to be good for business. And maybe it has been, but there's no evidence we have for it. So we really want to get conscientious about that. And so I do hope you'll keep us in mind when you decide to do any sort of estate planning.
Yeah, and keep in mind estate planning, like we were talking off air about, if you have pets and you don't have children, like the couple we just talked about, think about your pets and your will and your estate planning.
Yeah, I'd like to think that those of you who don't have kids and just have pets would think about something like that, but I don't think many people do. But I agree with you. I think it's
important.
Look, if I didn't have kids, that'd be front and center for me, particularly about a younger dog. But so we look forward to your joining us next time. This has been another episode of Life's Third Act. Take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell and Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.